Welcome to the last in my series of lectures based upon my book, Artificial Intelligence, Neurodata and Society, Law at the Edge of Cognition. The epilogue does not end with a spectacular prediction or a tidy regulatory program. It asks us to recognize a quiet reorientation. Across the book, systems move from recording behavior to anticipating it, from personalizing content to adapting environments, and from supporting decisions to learning how decisions emerge. None of these steps needs to look revolutionary. Each can appear useful, efficient, and defensible in isolation. The danger lies in accumulation. The background against which choice is exercised begins to change before law identifies an interference. This final lecture draws together the book's central argument. Cognitive freedom depends not only on keeping thoughts secret, but on preserving environments in which deliberation, hesitation, revision, and resistance remain genuinely possible. The legal challenge is to see architectures of influence while their operation still feels ordinary enough to escape contestation. The ending is deliberately sober because the decisive institutional choices will probably arrive through procurement, product design, and routine deployment rather than constitutional drama. The epilogue's first instruction is methodological. Slow down. The purpose is not to provoke panic about a single technology, nor to claim that one legislative amendment will resolve the problem. NeuroAI names a relationship between learning systems and cognition that cuts across devices, sectors, and doctrines. Treating the subject as merely technical obscures choices about institutional purpose, commercial incentive, and the distribution of power. Treating it as one more compliance problem fragments the inquiry before it begins. The book therefore resists both technological inevitability and regulatory theater. It asks what kind of influence our institutions have learned to recognize and what kinds remain invisible because they do not resemble command, deception, or discrete adverse decision. Recognition precedes solution. Unless law identifies the object correctly, more transparency, consent, and procedural formality may legitimize the architecture rather than constrain it. Slowing down is therefore an act of analytical discipline. It creates the space to separate beneficial assistance from architectures whose objective quietly colonizes deliberation. The change feels ordinary because it extends practices already embedded in digital life. Recommenders predict behavior. Personalization adjusts content. Optimization reduces friction. Decision support systems present guidance. The reorientation occurs when these capacities combine and become adaptive. Prediction becomes anticipation. Personalization becomes continuous environmental adjustment. Support begins to shape the process through which a preference forms. No confrontation announces the transition. A notification arrives at a convenient moment. An option moves lower on a page. A path becomes smoother. A hesitation triggers reassurance. Each adjustment appears minor and perhaps beneficial. Together they alter the cognitive background of choice. This incremental character explains why event-based law struggles. There may be no obvious line where assistance becomes influence or influence becomes control. The epilogue, therefore, asks us to examine the pattern, not wait for one spectacular violation to make the structure visible. What appears to be a sequence of product improvements can, at system level, become a transfer of practical authority from the person to an optimizer that never declares itself. Spectacular claims about mind reading can be politically useful because they focus attention, but they can also reassure us. We can dismiss the most dramatic scenario and conclude that the problem remains distant. The book's quieter trajectory is already plausible without direct neural access. Systems learn that typing cadence, voice, gaze, reaction time, or behavioral drift correlates with cognitive state. Neurodata acts as a reference point or training substrate rather than a permanent input. The resulting model operates through ordinary devices and across contexts. It does not need to know a sentence in the user's mind. It needs only enough predictive leverage to time an intervention, reorder an environment, or anticipate resistance. Prediction becomes preemption, and preemption becomes influence that does not present as interference. This is why a narrow focus on headsets and implants can miss the systems most likely to become ubiquitous. The immediate governance challenge is not to prove that a machine has literally read a mind, but to recognize when inference already supplies sufficient leverage to shape conduct. Law's comfort zone appears on the left side of this slide. Speech, conduct, transactions, identifiable decisions, and harms that can be located in time. Even when law examines mental state, it usually infers it from outward action. Neuro AI operates upstream. It learns in one context and acts in another. Medical ethics governs a device. Data protection governs a dataset. Consumer law governs influence, and human rights law invokes autonomy. Each silo supplies important safeguards, but the connective tissue escapes. A model trained on neural data may later influence a workplace interface through non-neural proxies. No single regulator sees the complete chain. The risk is therefore not only under-regulation, it is misrecognition. A systemic change in cognitive modeling appears as a series of ordinary sectoral compliance questions. The epilogue asks institutions to follow the architecture across context and to examine how inference becomes operational power. Cross-domain accountability must therefore follow learned cognitive capability through its institutional journey, rather than ending when the original data changes form or controller. The book does not claim that consent, responsibility, or autonomy disappear. It argues that they thin when law treats them as formal checkpoints rather than lived conditions. Consent can become a record showing that a box was ticked, even though the future inferential uses and adaptive effects were impossible to grasp. Responsibility becomes diffuse when outcomes emerge from layered models, design choices, optimization objectives, and human reliance. Autonomy persists in form. Options remain available, and no command is issued. Yet the environment has been tuned to inferred fatigue, susceptibility, or preference, making some paths easier and others costly. These concepts retain normative value only if law protects the conditions that make them meaningful. A valid choice requires more than the absence of force. It requires a decision space that does not systematically exploit the subject's preconscious states for an objective the subject did not choose. A checkbox, human-in-the-loop label, or formal right to choose cannot carry the normative weight assigned to it when the choice environment itself has been strategically engineered. The trajectory is not technologically inevitable. Design decisions, business models, procurement choices, professional habits, and regulatory defaults shape it. That leaves room for intervention, but only if legal imagination moves beyond isolated harm. Transparency notices cannot neutralize an environment calibrated to inferred vulnerability. Individual choice architecture cannot bear the whole burden when power lies in system objectives and feedback loops. Institutions must scrutinize training provenance, secondary cognitive use, adaptation strategies, and the cumulative distribution of friction and opportunity. Regulators need ways to audit architectures rather than only outputs. Designers need duties that preserve interruption, reflection, and genuine exit. Courts need procedural concepts capable of addressing influence before a formal decision appears. The task is stewardship of cognitive environments, sustaining the social and technical conditions in which people can pause, revise, and resist without those acts being treated as optimization failures. That program requires regulators, courts, and designers to treat friction not always as inefficiency, but sometimes as the practical infrastructure of reflection and independent judgment. The book's final warning is not that machines will suddenly know everything about us. It's that systems may know enough, early enough, to rearrange the world before we recognize what has changed. The mind has long served as a legal and political backstop, a domain in which power could not easily reach and freedom could therefore be presumed. That presumption is no longer secure. Sustaining it will depend less on a future breakthrough than on choices made now about model training, platform objectives, institutional reliance, and the design of cognitive environments. Once these arrangements feel settled, the opportunity to ask whether another pass was possible may pass without a dramatic moment of decision. The correct response is neither panic nor resignation. It is sustained legal attention to how influence becomes infrastructure. Do not forget to watch the full series playlist and return to the earlier lectures for the complete chapter-by-chapter argument. The series ends with an open institutional responsibility. Cognitive freedom will persist only if law notices how ordinary optimization redistributes the practical ability to think otherwise. Thank you very much for listening to my series.